Your Honor, my client gave a piece of her own body to save the plaintiff's life. This is case number 4471, Whitfield versus Serrano, a civil action for unpaid rent, penalties, and eviction. Counsel, opening statements.
Thank you, Your Honor. This case is simple. My client, Eleanor Whitfield, entered into a lease with the defendant. The defendant stopped paying rent. 6 months of non-payment, Your Honor. Whatever goodwill existed between these two women does not erase a signed contract.
Miss Ruiz. Your Honor, this case is not simple at all. What happened after Nerd was not a straightforward business dispute. The evidence will show promises were made and promises were broken, not by my client.
Objection!
Sustained. Save it for evidence, Miss Ruiz. Mr. Voss, you may call your next witness.
Mrs. Whitfield, please describe your relationship with the defendant.
Maria rented the garden unit behind my house for 3 years. She was kind to me. She used to bring me soup.
And in March of last year, you became seriously ill.
My kidneys failed. The doctors said I needed a transplant, or I would die within months.
Did Maria offer to help?
She did. She was tested. She matched. She gave me one of her kidneys.
But generosity is not the issue before this court, is it? After the surgery, did the defendant continue paying rent as required by the lease?
No. She fell behind.
By how much?
6 months. About $11,000 with the late fees.
Nothing further, Your Honor.
Miss Ruiz, cross-examination. Mrs. Whitfield, who filed this lawsuit? It was filed in my name. That's not what I asked.
Objection, argumentative.
Overruled. The witness will answer. My son handled it. Gregory has power of attorney over my finances. He's handled things since my surgery. Did you tell your son to sue Maria? I told him I was scared about money. That's not what I asked. No, I didn't tell him to sue her. Nothing further, right now, Your Honor. Defense calls Linda Cho to the stand. My name is Linda Cho. I'm the property manager for the Whitfield rental unit. Miss Linda Cho, you manage the Whitfield property day to day, correct? Correct. I collect rent, handle maintenance, that sort of thing. Who instructed you to send the first late notice to Maria Serrano? Gregory Whitfield. Not Eleanor? Eleanor wasn't really making decisions those first 2 months after surgery. She was too weak. Gregory told me to start the paperwork. Did Eleanor ever tell you, directly, to sue Maria? No. Honestly, when I mentioned the lawsuit to her once, she looked surprised, like she didn't fully understand what had already been filed.
Objection, speculation as to the plaintiff's state of mind.
Sustained. Strike the last sentence. No, not to me. Miss Cho, did Gregory Whitfield say anything to you about why he wanted to move quickly on this? He said his mother needed the income. He said he had his own situation to deal with too. Did he explain what that situation was? No, not to me. Your Honor, nothing further. Your Honor, the defense would like to enter Exhibit D, financial records obtained by subpoena, showing Gregory Whitfield's outstanding business debts totaling $43,000. Incurred 4 months before this lawsuit was filed.
Your Honor, this is a fishing expedition. Gregory Whitfield's finances are not on trial.
Your Honor, the defense contends the urgency and severity of this lawsuit, full back rent, maximum penalties, and eviction, filed against a woman recovering from a kidney donation, was driven by someone else's financial desperation, not Eleanor Whitfield's wishes or the actual terms of the lease. I'll allow it, limited to the question of motive and timing. Defense calls Dr. Samuel Okafor to the stand.
My name is Dr. Samuel Okafor.
Dr. Okafor, you performed Eleanor Whitfield's transplant surgery.
I did.
Describe her condition beforehand.
End-stage renal failure. Without a transplant, I'd estimate she had 2 to 4 months to live. She had no matching family donor and could not afford a paid transplant list wait, which can take years.
And the defendant's donation?
A perfect match. Rare, honestly. The surgery saved Mrs. Whitfield's life. There's no medical ambiguity there.
Are complications common for living donors?
Uncommon but real. In this case, Ms. Serrano developed a post-surgical infection and a hernia at the incision site requiring a second procedure. That's a documented, verifiable complication, not unusual for donor cases, but it does extend recovery significantly. Cross-examination. Doctor, isn't it true that donor complications, however unfortunate, don't create any legal obligation for the recipient? I'm a surgeon, not a lawyer. I can only tell you what happened medically. Nothing further, Your Honor.
Defense calls Dr. Rachel Nomura to the stand. My name is Dr. Rachel Nomura. I'm Maria Serrano's treating physician. Dr. Nomura, you treated Maria Serrano after the donation. She was hospitalized twice, once for the infection, once for the corrective surgery. She was medically unable to work for 5 months. Did she request this timeline, or was it required? Required. I personally signed the disability paperwork. Returning to work earlier risked serious re-injury.
Doctor, did Ms. Serrano communicate to you any expectation of rent relief because of her condition?
That's outside my role. I treat patients, I don't manage their leases.
Nothing further, Your Honor.
Defense calls David Park to the stand.
My name is David Park. I'm a neighbor of Mrs. Whitfield's.
Mr. Park, you've lived next door to the property for 11 years.
That's right.
Describe the relationship between Eleanor and Maria before the lawsuit.
They were close. Eleanor called her my girl. After the surgery, Maria used to sit with her on the porch every evening, just to check on her.
How did the neighborhood react when the lawsuit was filed?
Honestly, shock. Nobody could believe it. People were asking each other if it was some kind of mistake. Mr. Park, were you present for any conversations between Eleanor and her son Gregory regarding this lawsuit? No, I wasn't.
Objection. Sustained.
If you had to pick a side right now, the landlady or the tenant, who would it be? Tell me in the comments. I actually want to know.
Your Honor, defense moves to enter Exhibit F, a text message exchange between Eleanor Whitfield and Maria Serrano, dated 1 week after the transplant surgery. Read it into the record. Mrs. Whitfield's message reads, quote, "Don't you worry about 1 cent of rent until you're back on your feet. You gave me my life back. I'll take care of you," end quote. Sent from Eleanor Whitfield's phone number, timestamp confirmed.
Your Honor, a text message is not a lease amendment. It's a kind sentiment during an emotional moment. Has no binding legal force.
Noted, counsel. I'll weigh its legal weight in deliberation. It's admitted for the record. Mrs. Whitfield, do you recall sending that message? Yes. I remember exactly when I sent it.
Did you mean it?
Objection, asked and answered by the exhibit itself.
I'll allow the question once. I meant every word of it when I wrote it. Defense calls Gregory Whitfield to the stand.
My name is Gregory Whitfield. I'm Eleanor Whitefield's son.
Mr. Whitfield, you hold power of attorney over your mother's finances.
I do.
Did you file this lawsuit?
I filed it on my mother's behalf, within my legal authority.
Did your mother ask you to seek eviction and maximum late penalties?
She asked me to protect her financially. I made the judgment calls on how to do that.
Isn't it true you had personal business debts of over $40,000 at the time you filed this suit?
That's private and irrelevant.
Answer the question, Mr. Whitfield.
Yes, I had deaths.
Isn't it true the rental property is jointly held, and a portion of any rent collected passes through account you also draw from?
I managed the account for my mother's benefit.
That's not a no.
Nothing further, right now, Your Honor. Defense recalls Eleanor Whitfield to the stand. I'm Eleanor Whitfield, the plaintiff in this case. Mrs. Whitfield, knowing everything you know now, do you still want Maria evicted?
Objection, calls for a legal conclusion outside this witness authority given the power of attorney.
I'll allow it as to her personal wishes, not the legal outcome. Miss Ruiz, you may proceed. No, I never wanted her out of that apartment. I was scared after the surgery about money, about dying, about being a burden. I let Gregory handle everything because I didn't have the strength to. I didn't understand how far it had gone until I sat in this courtroom and heard it out loud. Nothing further, Your Honor.
Your Honor, sympathy is not a legal defense. A lease is a lease. The defendant owes back rent regardless of the donation, regardless of a text message, regardless of family disagreements about who filed what. The law must be applied
Equally.
Your Honor, the defense isn't asking the court to ignore the lease. We're asking the court to recognize that the plaintiff herself, in writing, waived rent obligations during the recovery period, that the lawsuit was pursued by someone acting outside his mother's actual wishes, and that the eviction notice itself failed to meet statutory notice requirements under the state's Landlord-Tenant Code, specifically the mandatory 30-day cure period, which the filed notice listed as only 12 days. I've reviewed Exhibit C, the eviction notice. Counsel is correct that it lists a 12-day cure period.
a clerical error, Your Honor, nothing more.
Clerical errors on statutory notices are still defects, Mr. Voss. I'll take this under advisement along with the rest. I've reached a decision. This court finds 3 things. First, the eviction claim is dismissed. The notice served failed to meet the statutory 30-day cure period required under this state's landlord-tenant law. That defect alone is sufficient to bar eviction on this record. Second, on the matter of the text message dated 1 week after surgery. While a text message alone cannot rewrite a signed lease, this court finds that Mrs. Whitfield's written statement, combined with her subsequent conduct of not demanding rent for over 2 months afterward, constitutes a valid oral and written modification of the payment schedule during the stated recovery period under this state's doctrine of promissory estoppel. Ms. Serrano detrimentally relied on that promise by not seeking alternate housing or emergency assistance during that window. Third, this court finds that late fees and penalty charges accrued during the recovery period covered by that promise are void. However, the underlying base rent for the recovery months remains a valid, separate financial obligation under the original lease, as no evidence was presented that rent itself, as opposed to timing, was ever permanently forgiven. Therefore, the eviction is denied. All late fees, penalties, and legal costs sought in this action are struck. Ms. Serrano is ordered to pay the base rent owed for the recovery period, $4,200, on a repayment plan of no less than 12 months, with no interest, as permitted under this state's hardship repayment statute. I'll add one more note, off the formal record, but for both parties to hear. The law does not require gratitude. It does require honesty. And it requires that promises made in writing, in good faith, be treated as more than convenient words to be discarded when someone else's hand is on the pen. This court is adjourned.
Would you have made the same promise Eleanor did? Be honest with me in the comments. I really do read all of them. Our next story, it's a father who signed away his daughter's inheritance and didn't find out what it cost him until he was standing in that same courtroom. Follow this page so you don't miss it.